Hello friends, Namaskaram, how are you? Do you think that it is not easier to get a bail in a cybercrime? We need to study the FIR. We have to know the legal provisions while arguing the bail plea. Then what you are doing, man? Simply you consult a lawyer and you ask us simple question. Sir, whether we will get the bail in this case or not. What do you think? If I say yes, do you think that you will get? If I say no, do you think that you will not get? Because my yes or my no cannot be your future. It depends upon you in which manner you are going to draft your bail plea. If your bail plea is not proper, your arguments are inconsistent, there is lack of corroboration, you could not be succeeded. So simply we could follow certain fundamentals so that we could be succeeded in our case and could internally put up a good case on record. Whenever we are arrested in a case concerned with cybercrime, the problem is that we are not having any idea about the subject. Can you do one thing? A thing which is quite simpler. Just note down the sections of the FIR. Go on Google and write down the sections and find out the quantum of punishment or imprisonment. If the imprisonment is less than 7 years or it is up to 7 years, then your arrest is illegal. The reason is that Honorable Supreme Court says if the arrest is to be done, the process could not be mechanical. The justification must be on the record, and apart from that, if the imprisonment is up to 7 years or less than 7 years, in that scenario, the concerned IO is duty bound to serve a notice to the concerned accused as per section 41A of CRPC or as per section 35 subclause 3 of BNSS. If there is no notice, it is a case of non-compliance, then we could have the benefit. It is easier now. You can do the same at your own level. And apart from that, if there is a delay in the FIR and there is no justification for the delay, you could have the benefit. If the allegations are strong, you are not having the plausible explanation. In that scenario, you could not be succeeded. So basically, it depends upon the nature of case. It depends upon the fundamental in which you will argue or you will put up your case. So the case which I will discuss with you is quite dominant on this subject. The judgment is pronounced by Honorable Uttarakhand High Court. It is dated 27th of Feb 2026. In that case, FIR has been registered as per the protocol of BNS. And apart from that, various sections of Information Technology Act are also added. But the submission of the accused was that no money has been received to him. There is nothing on record to show that he participated in the crime or he is having active knowledge about the commission of crime. So if the averments are non-specific, the allegations are general, and apart from that, there is no connecting evidence on the record, and even there is no ill motive on the part of accused to commit the crime. In that scenario, we are going to put up a strong case for the bail. And apart from that, the accused submitted that when he was in custody, he was compelled to give evidence, which is totally barred by section 22, 23 of the BSA. He submitted that he is not having the criminal antecedent, and whenever he was called by the IO, he cooperated and still is willing to cooperate. So there is no possibility of him to flee away from course of justice. He never tampered the evidence. He never disappeared the evidence. So looking to the facts and circumstances, the bail has been inclined. So whenever we are indulged in such a case, first of all, read the FIR. Ascertain your role if your role is not specific. And apart from that, you are not named in the FIR, the chance to get the bail will be on the dominant side. And apart from that, if your confession has been recorded, and apart from that, if any person is arrested, his confession is recorded, and on the basis of confession, you are arraigned as an accused, then the chance to get the bail will be on dominant side. And apart from that, if you are not having any criminal antecedents, in addition to this, there is nothing on record to show violation of section 480 subclause 3 of BNSS, means there is nothing on record to show that you tampered with the evidences, you caused disappearance of the evidences, the chance to get the bail will be on dominant side. So all these fundamentals are required to be kept by you in your mind while drafting the bail plea so that you could effectively put up a strong case for the bail. Last but not least, simply I want to say, just put up the plausible explanation to the allegation of the prosecution. If you are going to submit your application in general way, you could not be succeeded. If you are having the proper explanation of the allegations, and apart from that, you are able to find out the non-compliances of legal provision, and apart from that, if you are going to point out or if you are going to suspect on the allegation of prosecution, chance to get the bail will be on dominant side. And the long custody of accused is also one of the most important fundamental to get the bail, because if the accused is in custody since a long time, there is no progression in the case of prosecution. The chance to get the bail will be on the dominant side. So there is no need to ask to anyone. Simply you could identify at your own level whether you will get the bail in the said case or not. So I've specified you the fundamental along with the legal compliances. See you in the next lecture. Till then, Jai Hind, Jai Bharat.